This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
The privilege to be there before the High Court and the tribunal to argue the matter.
Of course, we are Jithan neutral, but the lady said that she would be arguing first.
No, without. In fact, I ought to have a case.
My lord, he had made a special request, and I said,
I have been considering to the request of others and getting without bogged down. Anyway.
We only thought that you would have it the last.
No, I have to leave. I have been staying here for the last 3 days. Now, the first petition was moved before the tribunal, seeking basically two relief that our employees posted at Chennai and Bangabhavan, Delhi are getting TA at the central rate. We are not getting it. The government is delaying in payment vis-a-vis the payment time scheduled by the central government. Therefore, let it be released. And the petition was dismissed by the Learned Tribunal, holding that DA is only a discretion by the government, you have no right. But from that petition first came before the High Court, that division bench of the High Court decided that no, this is a legally enforceable right. I will not repeat what she has seen that judgment, I should place that part. And so for the other parts concerned, then court directed that following L. Chandra Kumar, those issues should first be decided by the tribunal. Therefore, the tribunal will now decide whether the payment of DA at the rate of central government to a section of the government employees because of their postings at different places would be justified, and whether the non-payment of DA keeping in the time schedule or period released by the central government is justified. Now, the Honorable Tribunal thereafter, in fact, wanted to know from the State Council how they would really interpret their own rules. Now, in the background thereof, I will just invite my kind attention to the rules. If I may place, the rules are not very important.
Yes.
Kindly turn to page 126.
Yes.
And this 126 is preceded by the recommendation of the Pay Commission, that is at page 97. Though it was referred to, I am not taking my leave to refer it once again.
Yes.
Page 97, this is the annexure of the Pay Commission.
Page
97.
Yes.
So kindly come to paragraph 10.2.
Now we first deal with dearness allowance.
Yes. Due to the unabated pressure of inflation in the economy, the real value of salary fixed periodically by Pay Commission, so and so. Then the state government since 1st April 79, can note this, has been following the same principles followed by the Government of India in the matter of calculation of the quantum of each installment of dearness allowance. But almost invariably, there is a time lag in actual payment. And when the same is paid, the same does not include any arrears. Right now, only one such installment has remained due, which the Government of India sanctioned on 1st of July 2008. The last installment, which the state government has sanctioned with effect from March 2009, was sanctioned by the Government of India on January 2008. A major grievance of most of the associations of the employees has been non-payment of the DA installments in time. Now, this is the basic grievance which is still we are pursuing before the court. As per the Government of India's announced policy, this is payable twice a year, namely with effect from 1st January and 1st July each. As per information available, a chart is given. I am not troubling my lord with that. Then kindly will not turn to 10.6. It is evident from above that a state government sanction of the installment does not follow any definite pattern. It is also clear that there are delays in payment of various installments of DA, and there cannot be any differences of opinion regarding the need to avoid the delays. We are of the opinion that with some extra effort, the state government should be in a position to clear the backlog of the loan installment, which was sanctioned by the Government of India with effect from July 2008, then fall in line with the central government pattern of sanctioning 2 installments of DA each year we recommend this action, this course of action. It is done, it will mitigate a long-standing grievance. This recommendation of pay commission was accepted.
Yes.
And then the rules were promulgated under 309.
Correct.
Now, kindly come to page 162.
Yes.
This is the memorandum dated 23rd February 2009. This is in clarificatory memorandum of the West Bengal Service Rules 2009. 2009 rules, I shall come to your lordship.
Yes.
But kindly now come to next page. After clause 5.
Yes.
To make recommendation each of the clause 5E, to make recommendation each of the above having regard internally to the prevailing pay structure under the central government, public sector undertakings and other state government, etc., the economic conditions of the country, financial responsibility to the government of India and the pattern of allocation of revenues to the state, the resources of the state government and the demands thereon on account of the commitment of the state government to development activities. The Commission submitted its report on 12 February 2009. After due consideration of the recommendations of the Commission, the Governor has been pleased to make the decisions set out in the following paragraphs. That I emphasize it show that when government appreciated the financial responsibility, having appreciated that, took this recommendation into acceptance and issued rules. Then kindly come to page 166.
Yes.
166 is also very important. This is the continuation of the memorandum, which starts at the very same memorandum, 23rd February 2009, and kindly come to clause 10 at page 166.
Yes.
Consequent upon revision of pay of government employees in accordance with the West Bengal Division of Pay Rules 2009, the dearness allowance to which a government employee is entitled from time to time since the first day of January 2006 needs to be related to pay in the revised pay structure. Necessary government order in this regard has been issued with Finance Department memo dated so and so. Then this itself indicates that the government was very much concerned about the payment of DA periodically in terms of or in the pattern followed by the central government. Kindly now come to the rules at 126.
Yes.
By the way, can you notice the 23rd February 2009 is a very remarkable date. All these notifications are issued on the very same date. That will indicate how the government had appreciated and how the government wanted to implement. Now this rule, 126, kindly come to page 127.
No, can you just repeat that again?
This 23rd February 2009, when the ROPA Rules 2009 is promulgated, on the very same day, the clarificatory notice comes. The clarification says what I have placed, that they have to follow the pattern and they have to fix up in terms of the rules 2009, which is at page 126.
Can you just take us to the notification again?
166. This starts at 162.
The ROPA notification is dated
23rd February 2009.
3rd February 2009.
And this clarificatory was on 23rd February 2009.
Decimal page
162.
3rd February. Okay.
And another clarificatory notification is at page 168. There they show the chart how it is to be followed.
Yes. Yes.
Therefore, these three, the rules and these memorandums would have to be read together to find out the intention and the decision of the government vis-a-vis payment of dearness allowance.
Yes.
Now, Again, I will not come back to page 126 and the relevant portion at page 127.
Yes.
Where Lordship will straightway come to sub-rule C of Rule 3.
Yes.
Existing emoluments mean the aggregate of existing basic pay, dearness pay appropriate to the basic pay, and 4, dearness allowance appropriate to the basic pay.
Yes.
Plus dearness pay at index average 536.
Yes.
Without the base being 1982 equal to 100. Well, this 536 was arrived at by the Consumer Price Index Authority as of December 2005. Why 2005? Because these rules are being effective from January 2006. Therefore, the immediate available data of price index, that was 536, which is the base.
Right.
Subsequently, with the variation, nobody can say that the cost of price index would remain unchanged, unaltered.
Yes.
Then the concept of DA would go. DA is only for the purpose of mitigating the situation of price rise.
Yes.
Therefore, this, when the rule is given effect to from 1st January 2006, the available cost of price index was 536, taking 1982 as the base, as 100.
Yes.
Therefore, the basket which was available at the rupees 100 at 1982 is the basis, and on 2006 it is 536 rupees.
Yes.
Now with the change of DA you have to change it, and that is your own notification. No question of static. 536 is without completely static, it cannot be moved. That is in my humble misconception of the situation and the law. Now this memorandums will be read together. The High Court finds that this is an enforceable right, which has reached its finality. I am not going to argue on that. Then the matter is sent back to tribunal. Now, Lord should kindly take the tribunal's order,
Yes.
which is very important. So that is volume 2, page 428.
Yes.
Sorry, but it starts from page 463. But just for Lordship's information, the first division bench judgment which has held that this is enforceable right, but they did not prefer a bill, they preferred a review.
Correct.
The review was dismissed,
Correct.
and then they went back to the tribunal accepting the judgment, filed their affidavit and contested on merit whether we are entitled to the DA at the same cycle and rate by the central government or not.
Very good.
Here, Lord should kindly turn to
No, cycle word is not mentioned.
Pardon?
Cycle word is not mentioned in the
no.
High Court remand order.
Not
It is only rate which is mentioned.
the remand without is only without sending back the original application.
And this,
remand,
there was no cycle prayer.
no.
Your original application preferred before the tribunal at the inception.
My prayer was with the original application that release at the same rate.
Rate, not cycle.
Same rate means yes, same. So kindly comes with my prayers also. If your Lordship takes up my prayer B.
Come. High Court.
258. The High Court.
High Court has noted.
No, High Court has only sent back the
Come to
matter.
368.
368, yes.
368.
My lord. This is the division bench judgment.
Yes.
No, before Lordship.
Just
368, that is reproduced.
also need
Okay.
please ensure that what is up. You want the not please upload all. There, we have a practice here that our orders must be uploaded within 24 hours. There's a practice which this court follows.
Oh, that's wonderful.
Every order has to be uploaded within 24 hours. Therefore, we are telling his leave and upload it.
That's really
Because agree, this
Very
one already uploaded.
Well, this is
within 24 hours.
helpful for all of us. Now, kindly takes the trouble to come to prayers quoted in the.
She's elected because it's not the norm here. She should leave the court.
Well, at page 369, kindly see whether the original application prayers are quoted.
Page
369. This is the first division judgment which has.
No, we were quite doubtful. In fact, we put it to Mr. Padwalia, but couldn't get the answer. If the High Court had decided everything,
No.
it's not valid. That's how I read. We may have committed a mistake.
Sorry.
In reading it, if the High Court had decided everything, then what was the occasion for the High Court to remand the matter, and more so, para 84. And that's what is called.
Well, may I just tell your Lordship why High Court remanded it?
We only want to know page, what is the import of para.
I will take the Lordship. I will take the Lordship. The kindly sees below my prayer which was there in original application.
Sorry, we didn't want
No,
to discuss.
para 2, a direction upon the responding authorities. Para, that's at page 369. 369.
Since it is your baby, we thought, you are the best person to answer.
Yes, that's true.
Yes.
But a direction upon the respondents' authorities to forthwith release the 50% DNS allowance which was due up to January 2006 immediately. That is inherent. And then a direction upon the respondent to immediately comply with the report and recommendation of the Fifth Pay Commission positively and without fail within a period of 1 month from the communication. But the Fifth Pay Commission says that, and when I say that pay 50% of the allowance which is due, that comes due vis-a-vis that, then direction of respondents to release the 50% of DNS allowance as the state government without releasing the 50% DNS allowance for mere eyewash. Set up a sixth pay commission is not important, my lord. Therefore, this were the prayers. What the division bench has done, after having coming to the conclusion that this is not only a discretion of the state, this is an enforceable right, then kindly come to know why the High Court demanded it. Kindly come to that page 82.
Yes.
Or no, before that one, I just take the other part. Kindly come to that page 391,
Yes.
paragraph 76. Sorry for that, I probably have these. Yes, paragraph 52.
Paragraph 52.
Sorry, 52, 385. After considering,
Yes.
After considering the above report of LOPA 2009 was framed in exercise of power conferred by the so-and-so, therefore it is evident that the DNS allowance was also one of the components which came under the purview of its considering the rolling out of Fifth Pay Commission. Sub-rule 1 of Rule 12 of LOPA provided that no arrears of pay which government employee might be entitled in respect to the period from January 6 to March 2008, that this is the reflection of government's consideration of financial liability. Therefore, they said that this part you are not getting should be paid to the government employees. Needless to point out that the above decision included non-payment of arrear DNS allowance for the period. The government of West Bengal Finance Department Audit Branch that I have placed this, I am not troubling my lord in again. Let kindly come to paragraph 59, which Mr. Patwali has placed. I am not taking trouble my lord with that.
Yes.
Then kindly come to 68.
Yes.
Under sub-rule 1 of Rule 12 of the LOPA, it was declared that no arrears of pay to which government employee might be entitled in respect of so-and-so. I have already found that paragraph 10 of the clarificatory memorandum, February 23, 2009, and on allied matters provided that the DNS allowance to which the employee serving under the government of West Bengal was entitled from time to time. That this rules out the perception of stagnancy.
Sir.
1st of January needed to be related to pay in revised pay structure in this regard. This was the finding. Then 76.
Yes.
Further, the factors which were taken into consideration by the central government in fixing the rate of DNS allowance for its employees were required to be taken into consideration with those taken into consideration by the government of West Bengal. In the event the factors were common and same for both governments, then the element of arbitrariness were required to be examined in the context. These are all on the basis. Then why it was remanded? They kindly come to below paragraph 82.
Yes.
The claim of the employees serving under the government of West Bengal is based on legally enforceable right on all the employees serving under the government of West Bengal up to such extent recommendation of the pay commission which has been accepted by the government by OPA rules. Then finance given so and so. The claim of the employees serving under the government of West Bengal to get DNS allowance at a rate equivalent to that of the employees of the central government requires adjudication upon consideration of the relevant materials on record for the purpose indicated here above. The claim of the employees serving under the government of West Bengal for DNS allowance at a rate equivalent to that of the employees discharging their function in Bongo Bhavan and New Delhi and Youth Hostel in Chennai requires consideration of the materials which may be brought on record by the government of West Bengal. The aforesaid second and third issues, namely whether the claim of the employees serving under the government of West Bengal for DNS allowance at a rate equivalent to that of the employees central government, whether the discrimination in the matter payment of DNS allowance at the employees of state of West Bengal so and so, then court cannot be done in this seat application. As a court of first instance, in view of the principles of law settled in the matter of L. Chandrakumar, the learned tribunal is the appropriate forum to discharge the above function as a court of first instance. That's why it was demanded that only the issue which was decided by the tribunal rejecting the OA, holding that he was not entitled to, that issue was not considered, other issue was not considered by the High Court and said, go before the tribunal and get it decided. Therefore, the High Court had no more occasion to go into the other issues because those issues were not then yet decided by the learned tribunal. To the final judgment of the tribunal.
Yes.
Which was taken to the High Court, or High Court not refused it, refused it.
Yes.
Then now it's before the Lordship. Now kindly turn to the paragraph 28. Since the other issues which have been dealt with here have been repeatedly argued, I am just avoiding.
Yes.
I am straightway coming to paragraph 28.
Yes.
Since we have to examine whether the employees serving under the government of West Bengal are entitled to get DA at a rate payable to the employees of the central government, we need to first understand what are the issues and processes involved in payment of DA to the government employees. And the memorandum issued for payment of DA and revision of DA, February 23rd, 2009, which I have already placed before Lordship, we find the following similarities and differences in payment of DA to the state government employees as compared to the central government employees. DA has been paid as a percentage of the basic pay, not on the full package for both central government employees and the state government employees. Both the central government in terms of 6th Central Pay Commission and the state government in terms of 5th Pay Commission have used AICPI 1982 being 100 for industrial workers for measurement of inflation. This is very important. But the ICPI does not determine the DA, it determines the inflation on the basis of which the DA has to be determined by the respective governments. Therefore, AICPI is the basic norm. The base AICPI for calculation of DA with effect from January 2006, when DA has been considered as zero, has been the ICPI of 536 as per 1982 series, which has been same for the central government employees under 6th Pay Commission and the state government employees under 5th Pay Commission. In fixing the initial basic pay in the revised pay structure, as on January 1, 2006, the same AICPI has been used by both center and the state.
Continue.
Yes. Then in case of central government employees, it has been specifically mentioned in the notification that the inflation neutralization will be 100%, meaning thereby.
Continue, sir. Yes.
Now will be 100%, meaning thereby that DA percentage increase will be same as the percentage increase in the ICPI. So this is the finding of the tribunal itself. In case the state government employees, it has not been specifically mentioned that the inflation neutralization will be 100%, but the pattern of payment of DA in the initial years till 2010 indicates that the state government has also followed the same principle. Therefore, up to 2010, whether the state government followed the central government method blindly. 2011, with the change of dispensation, all these variations comes into operation. Now, it has been notified by the central government while accepting the recommendation of 6th Pay Commission that DA will be sanctioned twice in a year, January and July. This has not been clearly spelled out by the state government by the notification. Though on scrutiny of notifications, we find that while in the initial years till 2010, payment of DA was made twice in a year. But after 2010, the state government has not followed this pattern. The practice of revision of DA on January and July is done by the central government. The central government has notified that the revised DA on January and July will be payable with the salary of March and September respectively. This timely payment of DA as guaranteed compensation. Will kindly underline these things, which is very important for the purpose of fixing DA. Guaranteed compensation for erosion of basic salary within a reasonable period of time. In case of the state government, there is no such notification and no such principles have been followed, and there has been a long delay in protecting the erosion. This is the basic consideration. Now, comparison of payment of DA by the central government to its employees and by the state government to its employees, we find that the principles followed by the state government in terms of relationship between DA and the basic pay, use of AICPI as a measure of inflation, relationship between DA and ICPI and computation of DA are the same as that of the central government.
Yes.
The state government has followed the same principle for computation and payment of DA on basic pay fixed under 5th State Pay Commission, as has been done by the Central and 6th Pay Commission. The Central has revised DA twice in a year, January and July, on which DA is payable, while the state government initially paid twice in a year, but discontinued to pay twice in a year after the year 2010, and has delayed payments of DA without following any principle in an arbitrary manner.
Yes.
Therefore, whether this delay of release, if that is taken care of, I think the demands of the employees will be met. This is the grievance which the tribunal finds this is arbitrary.
Yes.
Division bench of the High Court has observed that DNS allowance is a legally enforceable right of the state government employees, which means that the state government employees have the right to be compensated for the erosion of their basic salary due to inflation. If the real value of basic pay decreases due to inflation, then the state government employees have the right to be compensated. And if such compensation is not given effect within a period of reasonable time, then their right to get compensated is infringed. Inflation changes with time, and thus the period of time within which the employees are to be compensated is extremely important. And as such, the right to get DA within reasonable period of time is an integral part of legally enforceable right.
We can't read
this.
Now, can I come to page para 33?
Well, yes, I was going to show that.
33.
31, Lordship probably had noticed.
Exactly, para 33. And that's what everyone has read. Both the sides have read.
Yes, we have read 33. I am at 33. We have already observed that there is no mandate, either under the statutory rule, namely ROPA 2009, or in the administrative directions issued by the state government in the form of memorandum, taken so and so, which are placed before Lordship. Now, in the absence of any mandate under the statutory rules or the administrative direction, we are unable to hold that the state government employees are entitled to get DA at a rate payable to its employees by the central government. However, from the discussions made by us here in what we can hold without hesitation, that the state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published. It is a bounden duty of the state government to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed in terms of ROPA 2009.
We may request you to please focus on this. Because also Mr. Patwale said how AICPI is applicable. Would you like to add something more to that? Is what we are asking.
No, I would not be adding a lot to bargaining the honorable court time and without patience. What I am saying,
we are very patient.
No, I feel that.
We have time.
But as a counsel, it's my duty to feel also what is
But what we are saying.
Therefore,
Core issue.
Yes, core issue.
Whether AICPI is applicable or not, this is the core issue.
No, it's applicable, no doubt.
What is the finding of the tribunal? What is the finding of the High Court? Is what we have to now consider. So therefore, in addition to what the courts have read, and what has been argued, is there anything else which you wish to
No,
add?
Lord, at the moment, Lord, I have nothing to say except that kindly come to 34. It's very important.
34. Yes. Let's see.
Now kindly come to 34. Next issue. For our consideration whether the payment of DA to the employees of state government at Bangabhavan in New Delhi and the youth hostel in Chennai at the rate payable to the employees of central government and payment of DA to other state government employees working within the state of West Bengal at a different rate is discriminatory. The admitted position is that the state government employees working at Bangabhavan.
But Mr. Diwan said that he is not challenging it.
So, therefore, the fact remains, Lord, today after this order, they say we have accepted this. The fact remains, Lord, so far the DA is concerned to the state government employees, some was getting at this central level. Therefore, you do not dispute and deny, I am on that.
Oh.
That the payment of DA at the central method
Yes.
was acceptable to you.
Correct.
And that's why you have paid to some of the employees.
Yes.
Now we have to, the tribunal says that there is no statutory mandate, but at the same time, tribunal says you have to evolve the method.
Yes.
The evolve the method for payment so that there is no erosion of the issue of payment of GNS allowance. But today price rise is indexed, that is rising. Now I am paid 2 years thereafter. In the meantime, further price rise. How would the employee cope up with that? Therefore, you are in fact frustrating the basic purpose of DA.
Well,
These are the basic things, on which I would like to emphasize upon. Therefore, the question of applicability of the AICPI is not under doubt. And the change of the pattern of payment up to 2010, the government followed the same. The government did not have any doubt that this should be followed. 2011 after, you have departed by not paying on time. Therefore, the payment of DA is not under dispute. The dispute is payment on time. Now, as I said, when you accept the Pay Commission's recommendation, you accept with the financial responsibility and liability. You know this. That's why you say you did not pay me the area from 2006 to 2008. That is a part of conditional acceptance of the recommendation. Therefore, subsequent thereto, you know that this is my financial liability. Now, you cannot just turn around and say, no, I don't have any finance. But though the finance is not there or not, but that is, they have the difference in the content petition before the High Court. The High Court must decide whether genuinely they have any difficulty or not. Okay. Now, the question of the finance, I just rely on one judgment and then let's stop. This is not 2022, Volume 4 Supreme Court cases, page 363.
so according to you, financial difficulty cannot be an installment.
Yes. Paragraph 57 continues.
Yeah.
Therefore, the defense of the state, the argument which was sought to be developed as a new argument, it was never argued before the tribunal or before the High Court. And the idea that DA gets stagnated on 536, to the deepest of respect, is totally the creation out of blue, without having any foundation. My juniors will insist me to believe that
even according to them, it is not static. It is swinging, but not the way you want it to.
No, that obviously is other difference. If they accept the way I want, there is no question about the litigation. But they have to have a reasonable. If they say, I do not accept you 100%, I have a reasonable way of doing it. State will not, in no way can not. Paragraph 38 at page 482. Yes.
38.
Well, kindly come to this. Yes, I had also marked it, but strictly. I'm reading out for what norms or principles have been followed by the state government for release of DA for its employees. No satisfactory answer in this regard came from Mr. Basu, the learned counsel representing the state.
Yes.
Mr. Basu merely tried to impress upon us that state government has following the pattern of the central government have admitted. Following the pattern of central government releasing DA to its employees, but the state government could not pay DA.
Which page you are reading?
Look, page 482, paragraph 30 of the plan. That's judgment.
We thought you are reading this judgment which you
No. Please. After without placing the judgment, juniors are prompting me that.
38 you are reading this. The function of the pleading is
Paragraph 30, page 482.
We have read it. Don't worry.
I was reading them, it was read.
We have read it.
So that's all. With that, I hope not your lordship will be pleased to hear it.
Next.
Please, may I take G?
Most certainly. In the phone voyage.